Okay, it is 8:03 a.m., August 18th, 2023. I'm going to go ahead and call the meeting to order of the full board. Our mission statement is to protect and enhance the public's health, safety, and welfare by establishing and maintaining standards of excellence used in regulating the practice of medicine and ensuring quality health care for the citizens of Texas through licensure, discipline, and education. And with that, we will have the roll call.
Yes, good morning, everybody. Dr. Zaffron.
Present. Present.
Present. Dr. Farmer.
Present.
Mr. Kokonos. We get your, I think you're still muted, Mr. Kokonos.
I don't know why. Good morning, President.
There you go. Hey, good morning. Ms. Barnes.
Present.
Dr. Bhatia. Present and on the road again. Dr. Deloche. Dr. DeStefano.
Present.
Mr. Gracia.
Present.
Mrs. Harrod.
I'm here.
Okay. Dr. Martinez.
Here.
Mrs. Morgan.
Here.
Dr. Naidu.
Yeah.
Dr. Nyack.
Here.
Dr. Quinones.
Present.
Dr. Tibbles.
Here.
Mrs. Todd. And Dr. Vanderwide. I think I counted 14 present. So we have a quorum. May proceed.
Great, thank you, everyone. First off is our board member report. One of the things that we did is, as you all know, the Federation of State Medical Boards continues to have its meetings, and they have webinars that they host on different issues, whether it be opioid task force issues, they're going into the realm of artificial intelligence, et cetera. One of the things that I thought was interesting that Mr. Carlton and myself attended as a webinar is addressing some of the issues around infusion clinics. And we watched the presentation that went into a little bit more detail on this issue, not just obviously here in Texas, but around the country. The FDA was part of that presentation along with other government agencies, and as well as some of the other boards from around the country, and some fairly good ideas about what they have done and what we may potentially embark on doing over here in Texas. One of the most interesting things that they did is they created a task force that was a joint task force between the medical board and the PA board, along with the nursing board, but also a model being out there, including the pharmacy board. And the idea being is that in many of these instances, whether it be an infusion clinic or there may be other entities out there that have a multitude of different licensees that are operating new different types of business models that we need to be able to catch up in regulating. This was a mechanism of being able to help manage that in a way that was effective. One of the things that that was made very clear in the presentation is that IV fluids by itself is a prescribed entity, is a prescribed product. So even though there's a lot of products out there that have IV fluids along with other medications like famotidine, ketorolac, different types of vitamins, even the IV fluids itself is something that is regulated by the FDA. And on top of that, hence the pharmacy board, what's also interesting about this is how these products are compounded, the sterility of these products. So it's not just about the operation of these entities, but it's also ensuring to the public that what is being provided and what is being given is something that is safe. From our standpoint, of course, as a regulatory agency, making sure that a physician-patient relationship is being established, that the appropriate and proper procedures are being followed in order to make sure that that patients are safe when being offered these types of products. Just as they proliferate, it's something that we are going to have to look at more and more. infusion clinics are one of the entities out there that we are going to just make sure that that are following proper regulatory procedures. There are other types of entities out there, med spas, ketamine clinics. As we become more and more virtual in this world, and as telemedicine becomes more proliferated out there, there are going to be entities like that, and we, that's good for the public from the standpoint of offering a product that they may not be able to necessarily receive otherwise. But we've just got to make sure from our standpoint that the public is protected in these types of entities that are out there with the products that are being used, and how patients are being managed and seen and evaluated and prescribed these medications or these fluids or whatever they might be. So more to come on that. This will be a continued topic of discussion. We've already had some conversations with other regulatory agencies here within the state, along with federal agencies outside the state, and you're going to see more and more of these types of collaborative efforts. Other things that we'll be talking about today, we are approaching the end of our fiscal year, and with the new fiscal year coming on board, we will talk a little bit more about some of the budgetary items that we were able to gain in the last legislative session, what some of these new opportunities will entail, especially around PHP, around the ability to hire more FTEs. This is something that will be discussed more and more later on. And the most important thing, of course, is making sure that we're taking care of our employees here in the agency. Inflation is out there. The cost of living in Austin's high, and making sure that they're taken care of by keeping us competitive and making sure that we are able to keep talent and hire new talent as we move on. So that's my board report. I don't know, Brent, I know you have your report later on. Anything that you wanted to add?
Nothing else to add right now, but like you said, I'll have more to cover here in a few minutes.
All right, great. Thank you. So moving on, agenda item number 3. Consideration and possible action for dispositions below minimum guidelines. You have 3 items under that agenda. Is there any extractions or recusals? Seeing none, I will entertain a motion to accept those items under agenda item number 3.
Motion to accept.
So moved,
Quinones.
Bhatia. Second.
Motion to accept by Dr. Quinones and seconded by Dr. Bhatia. And is there any further discussion? All those in favor, please say aye.
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 All those opposed? Agenda item number 3 passes. Agenda item number 4, consideration and approval of mediated settlement agreed orders. Are there any extractions or recusals on agenda item number 4? Seeing none, I will entertain a motion to accept, or whatever you guys want to do on agenda item number 4.
Motion to accept the items under number 4, DeStefano.
Thank you. Is there a
Second
second?
Barnes. Second
Seconded by
Barnes.
Ms. Barnes. Is there any further discussion on agenda item number 4? Seeing none, all those in favor of agenda item number 4, please say aye.
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 All those opposed? Item number 4 passes. Agenda item number 5, and as usual, there's a lot with these, so just kind of please pay attention to see if there's any recusals that you may have. On agenda item number 5, consideration and possible action for remedial plans. Under there, you have administrative rules, crime laws, which there are none, impairment, which there is none, peer review state action, which is none, and standard of care, which there is none. Are there any extractions or recusals under agenda item number 5?
Standard of
Sharif-
care,
Sharif-
there is, yeah.
Sharif, I've got a recusal and I'm trying to navigate to give you the number here. Anybody else does, they can jump in. We ready?
If you're voting or making motions, you do need to have your camera on.
Okay, my recusal is, we are on remedial plans, correct?
Correct.
We are on
Yeah.
remedial plans, that is
Yeah.
correct.
Number 5.
Okay, under standard of care number 21. Need to
Okay.
recuse.
All right, so Dr. Tibble is recusing on item number 21 under agenda item number 5. Anyone else? All right, I am going to specifically recuse myself on on item number 27 under agenda number 5. Okay, with that, is there a motion that we'd want to entertain on agenda item number 5?
I'll make a motion to approve the items under agenda 5.
All right, thank you. There's a motion and it's seconded. Who seconded? I'm sorry.
Dr. Deloach.
Dr. Deloche. So with that, is there any further discussion? All right, on agenda item number 5, with the exception of a recusal on item 21 with Dr. Tibbles and 27 by Dr. Zaffron, any further discussion? All those in favor, please say aye.
Aye.
All those opposed? All right, agenda item number 5 passes. Agenda item number 6, consideration and possible action for agreed orders. Under there, you have administrative rules, crime laws, there are none, impairment, peer review state action, standard of care, unprofessional conduct, and late orders. Is there any extractions or recusals on agenda item number 6?
Dr. Deloach, here I have a recusal item number 6, number 10. Under agreed orders, peer review, state action, standard of care.
Okay. Any other?
Naidu.
Dr. Naidu?
Item number 16, I want to excuse myself. Standard of
Okay.
care.
Any others?
Dr. Zaffron,
Yes, Michael.
I'll make a motion to approve consideration and possible actions for agreed order under number 6. Coconos.
Okay,
Second
there's
Barnes.
okay. Before we go on, I'm going to be recusing myself from item number 9 and number 10. Okay, so with that, is there any further discussion on agenda item number 6? Seeing none, all those in favor, with the exception of number 10 for Dr. Deloach, number 9 and number 10 for Dr. Zaffron, and number 16 for Dr. Naidu. All those in favor, please say aye.
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 All those opposed? Agenda item number 6 passes. Agenda item number 7, consideration and approval of modification request, termination request orders. Are there any recusals or extractions on agenda item number 7? Seeing none, is there a motion on agenda item number 7?
So moved, Bhatia.
Second, DeStefano.
Moved by Bhatia, seconded by DeStefano. Is there
Just
any
to
further?
Sorry, just to clarify, what was the motion? To approve,
to
I'm
accept.
assuming. Thank you.
Yes.
Sorry,
Move to
I hate to be picky, but we have to
yeah.
do it.
All right, so there's a motion to approve item number 7. Is there any further discussion? All those in favor, please say aye.
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 All those opposed? Agenda item number 7 passes. There's nothing on 8, which is consideration and approval of modification request, termination request of non-public rehabilitation orders. On number 9, there is one item, consideration and approval of cease and desist orders. Is there any extractions or recusals on number 9?
Dr. Zaffron, I'll make a motion to approve agenda number 9, consideration and approval of cease and desist orders. Coconos.
Okay, there's a motion by Mr. Kokonos.
Dr. Deloach would like to second that motion.
Okay, that's been seconded. Is there any further discussion on agenda item number 9? All those in favor, please say aye.
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 All those opposed? All right, motion passes. There is none on 10, 11, and 12. All right, it's 8:18, so it's appropriate for us to go to agenda item number 13. Consideration and approval of determination of default. So is Claudia, Ms. Kirk, or are you going to be doing it? Maybe?
I'll be presenting for
Okay.
board staff today. Okay. Hello, board members. This is Amy Swanholm on behalf of board staff presenting a proposed default order for Dr. Ferries. History with this proposed default order, there was a SOA complaint filed on April 20th, 2023. There was no reply from respondents. A hearing on the merits was held on June 7th, 2023. He did not show up for that, despite the fact that notice was properly found by the ALJ. The ALJ issued a default order the next day on June 8th, 2023. Staff has reached out throughout this process to respondent. He has responded, but has indicated at all points that he is retired and is not interested in participating. He appears to be suffering from some health issues and uninterested in maintaining his license at this time. We're available for questions if you'd like to ask questions. Otherwise, you could move to a vote on the proposed default order.
Are there any questions for staff on agenda item number 13? Seeing none, is there a motion on agenda item number 13?
Move for approval, Martinez.
Second to Stefano.
All right, we've had a motion and a second. Is there any further discussion? Seeing none, all those in favor, please say aye.
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 All those opposed? All right, number 13 passes. All right, and with that, we are going to do the consideration approval of proposal for decision, item number 14. We have one PFD, and I will pass it on back to staff.
Good morning, Nadia Burns for board staff. I would like to reserve any time I have left following this presentation for rebuttal. Respondent Jorge Guevara.
Hold on a moment, Ms. Burns.
Okay.
Brent, would you go ahead and check is anybody there, et cetera, on for the physician on the other side from Ms. Burns, please?
Yeah, there's not anyone that's here in the room with us. Do we have anybody that is on that is going to be representing the physician? Ms. Burns,
Yes.
Oh, okay.
Yeah. Hi, this is John Rivas.
Hey, how are you doing? Good morning.
Good morning, guys. I'm counsel for Dr. Guevara.
Okay, good. All right, just want to make sure you're on there. And so board members, you're probably pretty familiar with how this is going to go, but we'll have staff that will go first. They have a total of 10 minutes. And as Ms. Burns indicated, she'd like to reserve any time that she has left after her opening. And then Mr. Rivas will go next. And so you may go ahead and proceed, Ms. Burns.
Thank you. Respondent Jorge Guevara, MD, holds Texas Medical License J9070, issued on December 8th, 1995. On or about January 10th, 2019, the Department of State Health Services, or DSHS, conducted an inspection of the respondent's clinic and in-house radiology department at Medical Associates of Brownsville, or MAB. Respondent owns MAB and was also designated as the radiation safety officer. DSHS found several violations related to mammography services during the inspection, including but not limited to ensuring radiology safety at MAB and MAB's non-compliance with several regulatory requirements. DSHS also reviewed 30 random mammogram images from MAB and found that none of the images met image quality standards. On January 28, 2021, staff filed a complaint at SOA alleging that respondent failed to practice medicine in an acceptable professional manner consistent with public health and welfare, failed to use proper diligence in professional practice, and engaged in unprofessional conduct, including acts that violate state and federal law if the acts are connected with the physician's practice of medicine. Because the facts supporting these allegations have already been established and aren't open for dispute, I won't rehash them right now. So I'll just go on to, to the other allegations. A board also alleged that respondent also failed to practice medicine in an acceptable professional manner consistent with public health and welfare and engaged in unprofessional conduct when he, one, failed to adequately supervise the activities of those acting under his supervision, including an unlicensed radiology tech and his lead interpreting physician, Dr. Koblinski, as well as when he delegated professional medical responsibility or acts to a person he knew or had reason to know that the person is not qualified by training, experience, licensure to perform those acts. A hearing on the merits took place December 12, 2022, and on May 3rd, 2023, Administrative Law Judge Sarah Starnes issued a proposal for decision or PFD. Very quickly, I would like to just emphasize some of the major issues where the judge found for board staff. The judge's PFD, which the board members will find in their packet, found overwhelmingly that respondent had engaged in numerous violations, as previously discussed, and that his conduct was aggravated. In further demonstration of this, the ALJ rejected all of respondents' exceptions to the PFD and granted all of the board's exceptions. Specifically, the ALJ found that in addition to ratifying all the findings that I previously mentioned, the ALJ also agreed and found that 3 aggravating factors, which board staff alleged, warrant stronger sanctions against Dr. Guevara. Specifically, the ALJ agreed and found that it's undisputed that the board has entered into 2 prior agreed orders against Dr. Guevara, one in August 2010, another in February 2012, both finding deficiencies with his medical record keeping. Dr. Guevara did not assert any mitigating factors, nor did he directly respond to staff's arguments on aggravating factors. The ALJ also found that there were other relevant circumstances increasing the seriousness of Dr. Guevara's alleged misconduct, including his continued refusal to acknowledge and accept responsibility for the violations committed at MAB and as determined by the dishes proceeding. Finally, the ALJ found that the board staff proved that MAB's violations presented a hazard of potential hazard to public health and safety because the mammograms it performed were insufficient quality to detect breast cancer. In closing, what we're here to do today is sanction the respondent, Dr. Guevara, based on the findings. I'll remind the board that they don't have discretion to change any of the findings as laid out in the judge's PFD. Those have already been established and aren't subject to relitigating. Those findings support board staff suggested ordering provisions as follows. That the respondent be publicly reprimanded, respondent not own, operate, act as radiation safety officer for, or act as medical director for, or otherwise be associated with any imaging program, including programs that perform mammography, or any facility where imaging studies are done. Respondent shall not supervise or delegate to any healthcare personnel engaged in the performance of imaging studies. His practice should be restricted in that he may not perform any imaging studies. He be required to take and pass the JP exam, complete at least 28 hours of CME in supervision and delegation, risk management, mammography positioning, and mammography quality standards, and that he be required to pay a $10,000 administrative penalty. And with that, I'll pass it on to Respondents Counsel, Mr. Rivas.
Thank you very much. May I proceed?
Yes, please go ahead.
Thank you. So let me just address the comments by board staff first, and I'll go in reverse order. First, we disagree strongly that the proposed sanction that would prevent Dr. Guevara from performing, quote, any imaging studies is unreasonable. It is too far reaching. It would cripple and prevent Dr. Guevara from practicing medicine where he practices in an underserved area. it was essentially end his practice. So that proposed sanction is outrageous, unreasonable, and should be set aside. With respect to aggravating factors, okay, yes, Dr. Guevara signed 2 orders having to do with record keeping. The last one was 14 years ago. Dr. Guevara is a good, solid doctor. He's a valuable member to his community, and that should not, record keeping 14 years ago should not be considered as an aggravating factor. The other aggravating factor was the quote, continued refusal to acknowledge wrongdoing. This apparently is based upon the fact that Dr. Guevara simply requested an administrative hearing in order to give his side of the story. That a doctor's request to have a SOA hearing should not be considered as an aggravating factor for continuing to refuse to acknowledge any type of wrongdoing. So I'm going to move on to this. The board staff references the fact that there were poor images. Dr. Guevara is not a radiologist. His job as a medical doctor, he's not been trained to review images. He doesn't have the qualifications or training to determine whether an image is satisfactory or not. That was the job of Dr. Kapelivsky. And I know I'm mispronouncing his name, Kapelivsky, who the board already sanctioned in this case. Dr. Kapelivsky was the lead interpreter. He was the radiologist hired by Dr. Guevara's practice to review these images. In the hearing, Dr. Kapelivsky said that the images were not great, but they were satisfactory. So even the radiologist who reviewed these images, who had the most training, he never complained to Dr. Guevara saying, hey, these machines don't work, these images are no good. He, in fact, testified in this case that the images weren't great, but they were good enough. The other thing too is the board, the ALJ in this case, board staff is just recounting, I should say the ALJ in this case. When you look at their findings of fact, the ALJ simply adopted all of the findings of fact in the DSHS case. The DSHS case had to do with whether Dr. Guevara, in his role as the radiation safety officer, violated rules of DSHS. The DSHS does not regulate the practice of medicine. Our position is that because the conclusions of law, let me rephrase that, the conclusions of law are based almost entirely on findings of fact found by another state agency that was not looking at the medical practice of Dr. Guevara and not deciding whether or not his acts as an RSO were connected to the practice of medicine. That's what the DSHS was looking at. And so here's another thing too that's very important, is that Dr. Guevara was the radiation safety officer. The radiation safety officer, to be qualified as a radiation safety officer, you only need to have a high school education or a GED, right? Therefore, it is elementary and logical that the acts or inactions of an RSA, which are set forth for the record in TAC 25289.252F, those acts cannot and are not the practice of medicine. So anything that any violations of any DSHS rules by found against Dr. Guevara in his role as an RSO are by definition not the practice of medicine. So the criticism, and let me back, let me just say this. This case is controlled by the Supreme Court case of Alaman, which I'm sure all of the panel members are familiar with. That case held that, and it addressed this same rule that we're looking at here, whether it's connected to the practice of medicine. And that case, the Alaman case, in its analysis, when it was looking to see whether this so-called unprofessional conduct is connected to, gives rise to a violation of the rule, they looked at Occupations Code 164.052A5, because that section of the occupation codes gives examples of unprofessional conduct likely to deceive or defraud the public. All of them, when you read that, all of those are very much connected to the medical practice. None of those in any way come close to support an example of unprofessional conduct likely to deceive or defraud the public. None of those list anything even remotely close to a violation of a DSHS requirement for an RSO. So the one other thing that I want to point, because I know my time is limited, is that when you read the PFD, and as just commented by board staff, the ALJ considered the fact that in coming to the conclusion that Dr. Guevara violated the Medical Practice Act, the ALJ put significant weight on the mere fact that Dr. Guevara owned the practice. The problem with this decision is, well, there's multiple problems, but one of the biggest problems with this decision is that this decision sets precedent established not by the Texas Medical Board, but by the State Office of Administrative Hearings, ALJ. And what the State Office of Administrative Hearings, ALJ, is doing is they are saying essentially that anything that happens, any violation of any rule that happens within the context of a medical practice is therefore connected to the practice of medicine, and is therefore subjects the doctor, who happens to own the entire practice, no matter how big or how small, to exposure under this rule. So I will comment very briefly on the sanctions. Dr. Guevara was already fined $105,000 by DSHS. An additional fine would be merely punitive. It's unnecessary. Any acts or inactions that Dr. Guevara was guilty of has already been adequately compensated for. $105,000 is a gigantic fine he's already paid. The second thing is the requirement for, and I know that this is typical in most of these orders, but what we're talking about, what this case is about is, did Dr. Guevara was found to have violated rules of DSHS regarding RSO. Dr. Guevara was not found to have, practiced inappropriately. Dr. Guevara was not found to, there was no evidence that he doesn't understand what the rules of the Texas Medical Board are. So there's no reason for him to have to take the jurisprudence test. There's no reason for him to take further CMEs because, like I said at the very beginning, this case is not about what Dr. Guevara did or didn't do.
Sir, you have 30 seconds left.
Thank you. It's not about what Dr. Guevara did or didn't do to a patient. It's not about his quality of care rendered to a patient. Therefore, the additional CME regarding, mammography positioning, the Mammography Quality Standards Act, things of that nature, that's totally unreasonable. It's not necessary. So for those reasons, we strongly request that the board not adopt this PFD and set it aside.
Great. Thank you. Ms. Burns?
So first of all, I would like to emphasize that Mr. Rivas's attempt to relitigate the facts and applicable law is irrelevant for today's purposes. We're only here to provide remediation and to protect the public in terms of the sanctions being recommended. All of the facts and applicable law have already been established and heard by the judge and decided by the judge. So those should not be considered at all. With regard to Mr. Rivas's arguments about case law that applies, the Aliman argument was rejected by the ALJ. The ALJ also found other violations in addition to unprofessional conduct related to violations of other laws. Also, Dr. Guevara was the RSO and hired and supervised unlicensed people performing mammography. I also want to point out that the ALJ did find that the DISH's action was connected to the practice of medicine, and that entire issue has been well briefed, reviewed, and ruled upon by the judge. That again is just relitigation of the applicable law and should not be taken into consideration. And again, I'll just emphasize the only thing we're here to do today is review the proposed sanctions against Dr. Guevara and consider the aggravating factors that make those sanctions, that warrant those sanctions. And with that, I'll conclude. Thank you.
Thank you. I'm going to go ahead and just start off by asking some questions, and then I know that maybe some of the other board members may want to ask some questions also. So, Mr. Rivas, just to help clarify something for me. He was either an owner or overseeing imaging services. What responsibility within that structure, of hiring, owning the entities, all that kind of stuff, is there any type of responsibility that he takes from that standpoint within this whole enterprise that he was operating?
Yeah, so Dr. Guevara, he owned, and let me clarify something here. Dr. Guevara owned the medical practice, and within that medical practice, there were different departments. One of those departments was the mammography department. And for the mammography department, his role was the radiation safety officer. Dr. Guevara hired Kapelisky to be the lead interpreter. So Kapelisky was the one that actually read the images. Dr. Guevara's role as the RSO was not quality assurance of the imaging. It is not within his role as the RSO to ensure that the images are correct.
But the images are a product of the equipment and the structure, and we have some radiologists here on the panel, so I'm sure they would ask. But the point of the matter is, I'm trying to understand, as an owner of a medical practice, which is something that a physician in Texas typically will have, what type of because from what I'm understanding from you is that he has no responsibility in that. He's just hiring another physician. He's acting as a radiation safety officer, and beyond that, there is no responsibility. So why would a physician be the one who is required to own a medical practice that is responsible for the equipment that they have, which is the one that is producing the images that the other person's interpreting? So there is some type of culpability there. Who's acting as the medical director that is overseeing the function of all these things? So, I'm just trying to understand again because what you're suggesting here is that he has no responsibility whatsoever and no oversight whatsoever, even though he's the one who's doing the hiring, making sure that the equipment is appropriate, all that kind of stuff.
Right. And Dr. Guevara, are you still here? Okay. My response to that is at the end of the day, the issue with respect to the patients is, were the images, Guevara, are you there?
Yeah, I am here. Can you hear me?
Yeah, okay. do you have any
Okay,
comments?
Okay, usually in a medical practice, if it's a medical practice of 1 to employees, basically we have an office manager, usually who is basically in charge of basically of hiring basically employees. The office manager basically is making sure that the credentials of each employee are appropriate. And on the other hand, on this case specific, she basically called the Texas Department of Health, basically a inspector, and basically and asked for this. And her interpretation was that he was qualified. Basically, when I was informed that he was qualified. That's all. Okay.
So as an owner, it sounds to me like you're basically shifting responsibility to other people who are actually underneath you, which, hold on a second. So
Okay.
what I'd like to know, who is the medical director of this whole operation?
Is the medical director is Dr. Kapiliski. The medical
Dr.
director.
Kapiliski is the radiologist who's interpreting. He's not the medical
he's
director.
medical director.
Hold on a second. My understanding is that he's the radiologist who's interpreting the images. Who is the one who is buying the equipment, overseeing the employees, ensuring quality, essentially running the let me ask the question. Let me finish asking the question.
Okay,
And essentially running the operation of the practice, and don't tell me that you're shifting responsibility to other people. I mean, the person who's hiring your employees is not the one who is overseeing the physician that you hire and the equipment that you buy to oversee the product that you're actually putting out there.
May I talk now?
Yes, sir.
It's not about shifting responsibility. It's like in any place, like hospital. I mean, you have a CFO, CEO hiring that. You have a committee of physicians over there. So basically, me as an owner, we have like 40 employees. So I have an office manager who's basically making the interviews, checking that they have the license. So the owner is not going to be responsible. Hold on, let me finish. I haven't finished it. Or you want me to stop talking?
Good. Finish your answer. You can finish your answer, doctor.
Well, okay. So basically, first of all, I am trained. I am I am double board certified in internal medicine and substance abuse. Okay. So basically, I don't read mammograms, Mr. John Rivas said. So I am not qualified. I have never read mammograms. So I am not qualified about basically telling you about the images. Not because I am the owner, I am the physician of the facility. I have to learn mammograms. That's the reason that we hire a medical
I'm going to ask the question. I'm
going
to ask a very specific, because I'm not getting the answer. I'm going to ask a question one more time. Who is the medical director of this practice?
For the imaging is Dr. Kapiliski.
I didn't ask about the imaging. Who is the medical director of this entity here?
Yeah, but for imaging, I am the medical director. The medical
okay,
director,
that's what I needed to
but
hear.
The medical director doesn't hire.
No, I don't. I'm just this. Let me ask a question, and I'm just getting one answer. As a medical director, okay, I'm not talking now as an owner, but as a medical director, what is the responsibility of the medical director as it applies to the medical practice of your entity that is providing care to patients, and have you met those responsibilities?
As I said, I hired Dr. Kapiliski to be the medical director for the imaging department because I am not qualified to be medical director of the imaging department. Okay, the practice I am medical director, but I am hiring somebody who is qualified for that.
All right, thank you, Doctor.
Okay,
Dr. Farmer.
We'll keep. We'll get board members to ask any more clarifying questions they may need from Dr. Rivera, his counsel, or staff, and then obviously the board can go into an executive session for any further deliberations if they need to. But I think Dr. Farmer.
Actually, so it looks like there's a numbering system here. So Dr. Martinez, I think, is first. Yeah.
Okay, can y'all hear me?
Yes, we can.
Okay, so doctor, the question I had was, because it seems a little confusing, medical director, who's hiring, who's firing. At the end of the day, the owner of the clinic is you, right?
I am the owner of the clinic, yes.
Okay, and you do the billing and you do the collections, right? Your
Not
entity?
me, personally, not me, it's the company, it's Medical Association of
you-
Brownsville.
But your company receives the proceeds from that billing.
Medical Association of Brownsville receive the companies, yes, not me as a person.
Right, but the company of which you own and are the medical director of. So, is that correct?
For imaging services, we bill under Dr. Kapiliski for his services because he's
He's a sub-
qualified to read imaging.
Yeah, he bills the sub, I would understand if he bills the subcontractor reading interpretation fee.
That's
But
correct.
the facility fee for doing the exam in your building is collected by your entity, right?
Yeah, the professional service and the technical component are being collected by Medical Association of Brownsville. Yes, but we're billing professional component under his name because he's qualified that, not me.
Okay, but so whatever agreement you guys have worked out, the billing, the receipts come to you, that entity.
Yeah, yeah,
Okay.
but for his services.
Okay, that's what I want to know. Thank you.
Okay.
Okay, yep. Dr. Farmer?
Just a clarifying question to you, doctor. Do you understand what a lead interpreting radiologist is versus a medical director? Those are two different things.
Well,
Are you aware?
hold on. He is the medical director for radiologies, and he's the lead interpretive physician as well.
So he's the medical director of himself. Was he the only radiologist in the facility?
And actually, who supervised the text is not the RSO. The RSO doesn't supervise the text.
I didn't ask you about RSO. I did not mention RSO at all. I just asked you a simple question. Are you aware of the difference of a lead interpreting physician or radiologist versus a medical director? Because they're two different things.
I don't recall right now, but as I said, he was the medical director for the imaging services, and he was the leading interpretive physician for the imaging services. He was both.
All right, any other board members like to ask any questions?
Is he the one that purchased, this is Luann Morgan, a public member. So was he the one that purchased the equipment for imaging services?
No, he didn't purchase the equipment. The problem was not about the equipment or the engineer or the physicist. The problem that the person who was hired basically presented to the practice, lied to my office manager saying that he was qualified. My office manager called the Texas Department of Health, and she misunderstood that he was qualified. I was informed. I was not aware that he was not qualified. As soon as I was aware, I basically let him go and let her go. But I was not aware, so I will not make any changes when I was not aware. I was misinformed that he was qualified. That's all. But regarding physicists, machine, basically there were no issues about that. But he didn't purchase the machine.
So just kind of a follow-up to that, you know, because there are lots of medical directors now that quote unquote oversee things around the state of Texas, just like you are in this entity over here. And there seems to be this feeling that all you're doing is putting your name behind a document and calling yourself medical director of imaging. That doesn't mean anything. I'm the medical director of the patient that I take care of when I put somebody to sleep for anesthesia. I mean, that's different completely. And as Dr. Farmer said, we're the medical director of ourselves when we're taking care of our individual patients.
Mm-hmm.
But it doesn't seem to me that you're taking any responsibility as medical director for the running of your operation that you have ownership of in this type of entity. It seems like you're just shifting and so when we're talking about a PFD here that says that you can't be a medical director and perform these types of imaging programs, and you're saying that this is inappropriate for you, but that's exactly to the heart of the matter of this entity not functioning well with you as the leader of it as a medical director. And I think Dr. Farmer had a question.
Hold on. May I say something? May I answer your statement? Actually, I took care of that. As soon as I was aware that he was not qualified, I let him go, and I let him go my office manager. So I have been taking care of that. I was misinformed that he was qualified. You expect the medical director to interview each employee. When you have 4 employees, you expect to basically go through the credential and be a private investigator to see if qualified or not. Do the medical director. I don't know you're a physician or not, but look like sound like you're a physician. Basically, I can basically make sure that I don't know if you have private practice or not, but I mean, I don't think that you interview, you have 4 employees, you want to interview 4 employees, making sure that doesn't happen. As a medical director, doesn't happen. Has person that qualify, basically the office manager, the interview, they do that. I was misinformed, so I was not aware. See, if I was misinformed, I couldn't take care of that. As soon as was informed that was not qualified, I took care of that as a medical director. So the statement is not accurate, you know.
Dr. Farmer.
Okay. First, just a question. It doesn't require a lot of words, just a simple answer from you, doctor. Can you tell me in your practice, the percentage, a rough percentage that is made up of the radiology versus you have internal medicine there? What other services do you offer in your practice besides mammography and I'm assuming internal medicine?
We have physical therapists, and I have a physical therapist license.
So physical therapy, internal medicine. I think you also talked about at some point, maybe, did you have something else though, besides radiology?
I don't know what you're trying to. As far, I mean, I am board certified in substance abuse, so right. I see patients who have substance abuse. I mean, that's all.
Okay, so those 3 make up your practice?
I believe so.
Okay. All right, thank you.
Real quick, Mr. Rivas, you had mentioned earlier that, you know, one of the terms in the order that staff is asking for, that, you know, the respondent shall not perform any imaging services. The respondent has said that he doesn't do the imaging and that he is not, you know, he's not a radiologist. But you said something about if that term were left in there, it would take away his ability to practice. If I heard you correctly, could you clarify what that means? I mean, it sounds like he has other types of medicine that he is doing at this location.
Right, and I just want to make, and can you hear me? I'm not sure if you can
yes,
hear me.
Yeah, we can hear you.
And Dr. Guevara, it was my understanding that within the context of the medicine that you practice, that it's necessary to perform some imaging, you know, X-rays or something along those lines. And isn't that correct?
We do also ultrasound. I mean, some patients that they need it, we'll do it. I mean, we don't do a lot, we'll do a few of them.
Right, and so that's what I meant, board members, that the board order appeared to rule out any imaging, and I just want to make sure that Dr. Guevara still has the ability to perform the type of imaging that is necessary to, you know, care for his patients. And if I heard it correctly, Dr. Guevara, correct me if I'm wrong, but you do, what are the types of imaging that perform that are necessary for your practice?
Sometimes we do CTs and MRIs, and then we do ultrasound. That's all that we do at this time.
You perform that yourself?
No, I don't perform. I just mentioned. I have
so you can order it, and you can order it, and a functioning entity.
Only what I do is I order. Okay, I order as a physician. Like sometimes the patient go to the hospital, I order the MRI for the hospital. Okay, I don't perform the MRI. I order. That seems to me has to be correct. I am not a tech. Okay, I am not a radiologist, so I order the test. That's all what I do. The same thing with a mammogram. I never performed a mammogram. I never read I never read a mammogram. You know, I am not qualified. Only I order a mammogram for a screening mammogram. A lady 50 years old, they need a screening mammogram, or a lady before with high risk factors, they need a mammogram. Or sometimes I order MRI of the breast when they have high risk factors. You know, all of that I order, but doesn't mean that I perform.
All right, doctor. Thank you. Do you perform ultrasounds?
I don't perform anything.
Okay. All right. Just want to make. All right. Thank you, Dr. Quinones.
When we say we do imaging, I order. That's all what I do.
Dr. Guevara, this is Dr. Quinones. I think you've answered this, but I want to hear it one more time. Are you the owner of this entity?
The company, Medical Center Brownsville, I own the Medical Center Brownsville, yeah.
So you are the owner of this company.
Yes,
Are you the medical director as well of the company?
that's correct, yes.
So you are the captain of the ship.
I am the captain of the ship, that's correct.
Thank you, sir. That's all I needed to hear.
Yeah, but when the captain of the ship is being told something different, there's nothing they
Dr.
can do.
Martinez? Dr. Martinez?
Yeah, I think it's a distinction. And Brent, back to your distinction, I think what we're talking about, or what I would need to understand is, we're not saying he can't order any tests, but administering tests and doing tests at the office. That's what I would be interested in understanding, what gets done and gets administered by his business. Ultrasound, x-rays, MRI, CT scans, what the enterprise does. What tests does the enterprise perform and bill for, as opposed to saying he can't, we're not saying he can't order any tests. Just
Right,
what tests his enterprise administers.
Yeah, what's in the draft order here, it talks about he cannot perform it and he shall not supervise or delegate anyone doing it. So
Okay.
it sounds like he wouldn't be doing it in-house, but he could order them to go and get it done somewhere else and come back with the results.
As I said, I never perform. I order as a physician. The practice has performed. Myself, I never perform. So there is a distinction between me performing.
Yeah, so I believe the distinction that we're making in the proposed order is that you cannot be overseeing or supervising an entity that you own that will be performing these images if this PFD is approved. So, but you are more than capable of, just like any physician, of ordering an exam or an ultrasound or a CT or an MRI or whatever it is that you need to order that can be performed in a place that is qualified and appropriate to do so.
Well, hold on. Medical Center of Brownsville is qualified because it has a radiologist, it has 35 techs. Whatever happened in the mammo, it was misinformed, but doesn't allow basically to say that everything is disqualified. That's not correct, because I have ultrasound techs that are qualified, MRI CT techs that are qualified, they're licensed.
Okay, thank you. Mr. Nayak? You're on mute. You're on mute.
Dr. Guevara, this is Dr. Nayak. I just want to ask you a couple of questions. The first question is, you own the company and you are basically responsible for the upkeep of all the equipment and everything in this company, isn't it?
Sorry, what do you say? Can you repeat it? I didn't understand you.
I asked if you are responsible for all the equipment that is there in this entity.
Yes.
So it is your responsibility to ensure that
hold on.
The quality of the equipment
I want to make a distinction. Personally, I don't own. The company owns. I own the company, but the company owns the equipment, not me.
Yes, but isn't it your responsibility as the owner of the company to ensure that the equipment is in good working order?
Has always been in good standard, the equipment. Has never been questioned about that.
There were some problems with the quality of the imaging. So
Because
isn't that malfunctioning of the equipment?
It was about the technique, because he was not qualified.
So who was responsible to ensure that the technique was right?
The radiologist, because I personally don't read mammals. That's what I'm saying.
So
I am not qualified.
Did he at any point tell you that did he at any point tell you that the equipment was not functioning properly so that you could fix it?
My attorney just mentioned before. I was not, he never mentioned to me. He was never be aware of the issues.
Thank you.
I just said that.
Dr.
My
Tibbles?
attorney mentioned that.
Yeah, I think this is a question for the attorneys. And if this is all adopted, if he were to relinquish his medical director position, hire another medical director, is the jurisdiction of this order, like, would it still be applicable? Or, I mean, is this in his capacity as medical director of this entity or also as owner? I'm just looking for clarification, as if I'm And then we should maybe discuss how we feel about that, because if I'm in his shoes, I'm thinking, okay, I'm not the medical director. I will hire a contract with the medical director. I own an entity and business as usual. And then if so, how do we feel about it?
Well, I think what you're asking, Dr. Tibbles, would be is a legal question considering what options you may or may not do. Now, as far as the scenario that you're placing out there, that would be really more of us giving you legal advice within the context of an executive session related to what you can and can't potentially do within the scope of your discretion as well as your jurisdiction. Now, the easy answer is if you're a doctor and you've got a Texas medical license, we have jurisdiction over you. Now, the other part of this is if there is structure set up in a way which theoretically would be used to circumvent the law or the effect of the order, that is, again, something that would require legal analysis. So I would leave it at that and tell you, if that question comes up, depending on what you do at this point, if you decide you need some legal advice, we can do that. But you can also act on the order as proposed by Ms. Burns right now without executive session, but it's entirely up to you.
Okay, thank you.
May I have a question?
Yes.
So basically, me as an owner make me medical director or everything. Any owner or any private practice is going to be medical director or anything. Therefore, is guilty for everything happening in the practice. That's how you perceive. That's correct.
That's not an answer that I'm going to give right now. That we are looking at a specific. We are looking at a specific.
That's where we're going. That where we're
Doctor,
going.
we're not. The board is not going to give you any legal conclusions or analysis on that.
But this is
proposition.
basically.
Mr. Rivas, can you? Yeah,
can
please.
I just had to ask one clarifying question, because we've been talking about whether Dr. Guevara does any imaging, and then Dr. Guevara just mentioned, it sounds like, and please correct me if I'm wrong, Dr. Guevara, but it sounds like it's possible that you personally are not performing any imaging, but it sounds like currently within your practice, under the roof, there is imaging occurring. Is that accurate or not?
Yeah, under the practice, yes.
Okay,
Yes,
so
that's correct. That's accurate.
So I just want to, and Scott, what I'm most concerned about is does the order as written prevent Dr. Guevara from performing any imaging, and or does it also prevent Dr. Guevara's practice, which I understand now, which I always thought was the case, from anybody within the practice performing any imaging? And that's what is, I think, what I'm really most focused on.
Right, Mr. Rivas, and I think Mr. Carlton, exactly, that's why Mr. Carlton asked the questions in the way he did of you, quite frankly, to get that clarification. And I think that is one of the things, obviously, that the board will likely be considering as they go forward on this, and that may be a question that needs to be answered. And the other part of that is, and we've worked for many years together, Mr. Rivas, the other question is, even though this is an integrated clinic, if you will, do the patients understand that Dr. Guevara basically owns everything under that roof, including all services being provided? So when they get sent for an MRI, they don't think that it's being billed or to a separate entity, and know there may be some income flow back to Dr. Guevara, at least indirectly through reimbursement, insurance, etc.
Okay, I just wanted to make sure that the board understood that clarification, that in fact there is imaging that's occurring at the medical practice owned by Dr. Guevara that is necessary in order for the medical practice to render.
Yeah.
Service. Okay.
Yeah,
right.
and I think we have a full, definitely on the legal side, Mr. Carlton, and I think the board members all understand there may be, there's some intricacies that may be involved in the exact wording depending on what the board may decide at this point, Mr. Rivas. So yes, I think you can be fully confident that they recognize the distinction or at least the intricacies that you are articulating, particularly in response to Mr. Carlton.
Thank you, Mr. Rochelle.
And I think to answer your question some more, Mr. Rivas, the first term of it says that respondent of the draft here, respondent shall not own, operate, act as radiation safety officer, act as medical director for, or otherwise be associated with any imaging program, including a program that performs mammography in any facility where imaging studies, including but not limited to mammographies, are performed. And then it goes on to say he shall not himself perform any imaging services or supervise or delegate anyone doing imaging studies. So it's contemplating both. You can't own and
Yeah, I know,
can't do
but
it.
may I say something? Why does he say that if I have never performed that, I mean, to start with? I mean,
Yeah, we understand, Doctor, and I don't mean to cut you off, but John, I think we both understand the concept, and we certainly understand Dr. Guevara's question, but at this point, this is, somewhat redundant on his end, but particularly I think with yours and my discussion and Mr. Carlton, we understand the intricacies. It may be something that, depending on what the board does, you may want to talk a little bit more with Dr. Guevara, but again, this is all going to be contingent, as you know, Mr. Rivas, on what the board says, whether they say it in the next 2 minutes or if they deliberate for 2 hours and come back on. And you've seen it go both ways in your experience. So I think if you could be a little explanatory to your client, I think it would be helpful for him to understand kind of the process on the board's end, but also the impact once the board comes out. I think that would be quite helpful.
So thank you for that discussion. Did board members have any more questions for respondent, his counsel, or staff?
I have one question.
Well, sorry, right now I'm asking if the board members have any
Only-
questions. Sir,
Yeah.
sir,
Okay.
I'm asking if the board members have any questions.
Okay, sorry.
Okay.
I just have one. This is Batia.
Yeah, go ahead, Dr. Body.
Do you pay yourself do you pay yourself a medical director fee, or how do you compensate yourself since you're the owner of the whole organization?
I never pay any penny. As I say, the medical director of imaging, it has been Dr. Kapiliski. You want to call me medical because I am the owner. You want to call me the medical director of the practice, but I never pay any penny to myself as a medical director to my practice. I am the owner. I mean, it's a private practice entity, but I never pay any penny.
So are you saying you make no money from this practice?
No, what I said is he asked me if I got paid money as a medical director for the practice. The answer is I have never got paid any penny as a medical director from the practice. That's what I said.
Okay, great.
Well, how do you compensate how do you compensate yourself then?
Okay, well, we compensate because basically at the end we receive the money. I have a salary and basically that's it. But I never got payment as a medical director.
All right, would any board members like to go into executive session for further deliberations and advice from counsel?
I would entertain that we go into executive session for advice of counsel.
Okay.
And I'll second Farmer.
Okay, so we have a motion by Dr. Zaffer and a second by Dr. Farmer. Any further deliberation on going into executive session? All in favor, please say aye.
Aye.
Any opposed? Okay, thank you.
All right, so it has been moved and seconded that the board close the meeting to the public and has been voted on. There being no objection, this meeting is now closed to the public at 9:12 a.m. on August 18th, 2023. The meeting will continue in executive session for the purpose of private consultation and advice of counsel concerning pending or contemplated litigation, settlement offers, and or legal matters subject to the attorney-client privilege under the authority of the Open Meetings Act, Section 551.071 Government Code. While in executive session, the board will not take any action, make any decision, or vote with regard to any matter that may be considered or discussed.
Great, and we'll be utilizing breakout rooms for this executive session. So the board members will be moved into a separate room. For those members of the public, you'll just sit tight in this main meeting area here, and whenever executive session is concluded, the board members will return and will continue the meeting.
So I will wait for your cue to tell me when we are ready.
Looks like we lost Dr. Bhatia in the switch. Let me get him back in.
Do we have a quorum?
Okay, got him back. It looks like we're good to go.
All right, thank you. So the executive session ended at 9:54 a.m. on August 18th, 2023. There was no final action, decision, or vote with regard to any matter considered or discussed in executive session. A certified agenda of the executive session was made. All right, so now we have an opportunity for some deliberation by the board members only. And if there are any questions of staff, it would be appropriate then. So I'm going to hand it off to the board. Are there any questions or any comments that you would like to make? So I know that one of the things that has concerned me in general is making sure that we as licensed physicians have a very clear understanding of our responsibilities when it comes to ownership of a practice or medical directorship of a practice. It is very important that we not utilize that as a signature on a page, but as a responsibility to provide the service that we are licensed to do. And again, ownership of a medical practice is part of that. It's not just the provision of direct medical services, not just seeing a patient, not just diagnosing and treating a patient, but also the running of a medical practice. It is something that in the state of Texas is very clearly under the purview of a physician. And we've got to make sure that we take that responsibility and that role very seriously. Any other board members want to make any comments? All right, is there a motion that any of the board members would like to put forth?
Yes, I'd like to make a motion.
Okay, Dr. Farmer?
I move that the board adopt the findings and facts and conclusions of law as recommended by the administrative law judge in the proposal for decision. I further move that the board approve the suggested final order filed in the matter by board staff, except for the following changes. I would like to delete the CME credit requirement for mammography positioning to be deleted. And I would like to add that the doctor have the PRO program plus through the CPEP program. That concludes the motion.
Yeah, so before you is a motion, an amended, a motion with an amendment in it. Is there a second?
I'll second it here.
Seconded by Ms. Harrod. Is there any discussion on the motion? All right, seeing none, all those in favor, please say aye.
Say aye.
Aye.
Aye. Aye.
All those opposed? All right, the motion passes. Thank you very much. All right, moving on to the next agenda item is our executive director report. Mr. Carlton?
Yes, thank you. We've been going for a bit now and wanted to go ahead and jump into our audit. I think we have our Representatives from Weaver with us still, I hope.
Yes, I'm still here.
Hey, good morning. Thanks for being patient with us. Appreciate it.
No, my pleasure.
Please go ahead, and I know there will be something that the board will have to take a vote on at the end of your presentation.
Yes, just a quick status report for the board. We met with the executive committee yesterday and went over this in detail, so I'll keep this brief. We did finalize and finish the internal audit plan for fiscal year 2023. With that, we had a follow-up over 3 different audits that still had findings that were open. That was the Texas PHP report, a report over revenue, and report over registration. In summary, all the findings we had from those 3 reports have been remediated by the administration of the board. So just wanted to report to you that positive progress. There's one follow-up that we did not do any work on. That is over the state auditor's office report over cybersecurity. The medical board IT staff are still in the process of implementing changes in regard to the results of that report. And those are targeted to be complete December 31st of 2025. So we did not perform any audit procedures there to expend any of the internal audit budget, and something that we knew would not be finalized until a couple years down the road. So with that, there are 3 open findings in totality out of all the internal audits that we performed over the past 3 years since 2020. And all 3 of those are findings that were a result of the current year audit. So you only have current findings open. That's just a real positive report, I believe, and wanted to commend the agency on its diligence on remediating issues. The final report that we have is the annual internal audit report. That report, just as a quick reminder, is required by the Texas Internal Audit Act. The contents of the report are prescribed to us by the state auditor's office. We've prepared that report in compliance with those requirements. The only thing in there that I want to highlight in particular is there is a section that is a disclosure on the fiscal year 2024 internal audit plan. Prepare an internal audit plan for fiscal year 2024. Our contract as the outsourced internal auditor for the board expires August 31st of this year. And after consultation with Brent and his team, we determined that the best course of action would be to wait until the medical board puts out an RFP for a new contract, and whoever the vendor is that prevails and is selected as the internal auditor as a result of that RFP would be their opportunity to update or perform a risk assessment and then prepare a 2024 audit plan. So we just included that in the report, and that we did not create it, and that the selected auditor would prepare that when that occurs. Whoever that firm is or that individual is would need to then submit that to the state auditor's office, the LBB, and the governor's office on behalf of the agency once that plan is approved by this body here. So that is it. We've again completed all our plan and the requirements under 2023 and prepared the annual report. So when you approve that, we will then submit that to the governor's office, the LBB, and the state auditor's office on your behalf, and we will have completed all the requirements and satisfied all the requirements as part of our contract. Any questions? Well, thank you very much. It's been a pleasure serving with the board. It's been great having you as a client, and we hope to be able to continue our relationship with you down the road.
Great, thank you, Dan. You need the board to vote on the internal audit report, correct? I mean, that's what the ultimately will need. Yeah,
that is correct.
Yes, thank you. So board members, there is a motion for us to go ahead and approve and adopt the internal audit report. Is there a second?
Farmer.
Second.
And the motion was made by myself, so seconded by
Farmer.
Dr. Farmer. Any further discussion? All those in favor, please say aye.
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 All those opposed? All right, very good. And again, Mr. Chris, thank you so much for your service. And it was great working with you for the last many years, including over the year period of the pandemic.
Yes.
So,
Yeah.
and thank you for your service.
Yeah, you guys have been great. Great team to work with. Again, we appreciate all your help and helping us be a better agency, and your flexibility throughout the pandemic and finding ways to adjust and still get the work done on time. So we really do appreciate it.
Thank you.
Okay. All right, we will continue on. So for the budget update, we did get the finance committee was able to hear, but Joey, if you wanted to give them this quick rundown of what we got for the last couple weeks here.
Of course. Thank you, Brent. Good morning, board members. So as I mentioned yesterday, the agency's financial position through the end of July, our budget executions at 96%, and our revenue collections were just over 36 million. We do have 2 weeks left in the fiscal year, and our current budget executions at 99%. We will execute 100% of our budget and over the next 2 weeks. And as of yesterday, our revenue collections were just over $38 million. So we've met our expected targets and goals reported to the Legislative Budget Board and the Governor's Office and the Comptroller's Office. And we've also exceeded what we collected last year. Last year, we collected just over 37 million. So everything's going great. Fiscal year 24, we'll get that started September 1. And I'll hand it back to you, Brent.
Thank you, Joey. So continue on with money. So the last time in the June board meeting, the legislature had passed the budget, but it was still pending the governor's signature. That has happened. So we were very appreciative of the legislature and the governor for the additional resources that we were able to get. So to kind of quickly just recap on that, we got a little over 57% of what we asked for as far as exceptional items. So that is really going to help the agency a lot. We got 30.5 additional FTEs plus another 5 FTEs for the NPDB funding. And we'll talk about that here in a second. We got money for additional salaries and raises for staff. There's a couple of things with that. The legislature ended up passing a 5% or $3,000, whichever is greater, increase for all state employees beginning back in July, on July 1st, and there will be another 5% or $3,000 that'll be added at the beginning of next fiscal year in September 1st of 2024. In addition to that, we also did get some money, additional money for some targeted raises for staff. There was another increase that came for staff as well. And so we'll have more to announce to staff at an agency meeting that's going to take place next week on kind of what the final numbers are going to look like. But again, we did receive additional resources to help address some of the inflation issues that have been going on and making it more difficult for people to buy everyday necessities. So again, very appreciative of the legislature for that and all the work of the staff and the board and stakeholders and anyone else out there that helped advocate to the legislature on what we needed and why we needed it. A couple of the things that we got in the LAR are for some projects. So that includes a website update and a refresh that will be taking place over the next couple of years, an e-file document management system, enhanced customer service engagement, records retention and scanning. We still have a lot of paper documents that we're trying to get rid of the physical copies and turn them into digital ones. And then also able to build out a little bit of extra space that's still here on the 9th floor that has not been finished yet. And so we did get some money for us to be able to expand into that area, which is actually just across the hall from our ISC room, which someday here in the near future, you guys will get to see. And we'll talk a little bit about that too. We were planning on trying to have our first agency meeting all back together in October. It Don't know if that's going to quite happen yet. We're still waiting on Texas Facilities Commission to finish out the building. As you can see, we're still waiting on parts to come in for some of our audiovisual equipment in the ISC room. The boardroom in the building is still under construction. It has a targeted completion date, I believe, of October 1st, but it's looking like they may not be able to meet that timeline. And our board meeting would just be a couple weeks after that in October. So we may be looking at December as the time to do an in-person meeting. But we were able to get a lot of additional funds. The building overall is nice, but it still has some problems in it. Glass is starting to randomly break in around the building. It happened in Chris's office over here while he was sitting there doing work. The window just kind of shattered out of nowhere. It's happened elsewhere around the building. I think they told us we could expect about 1% of the windows to break. We're not really sure what exactly is causing it. I don't know if it's the heat or the way they were installed or manufactured or what it may be, but they are looking into it and figuring out how they're going to go about trying to fix the broken glass that is occurring around the building.
It's old man hobby. Old man hobbies running around that building.
Maybe.
It's a ghost.
Maybe.
Ghost.
Yeah, we did see that the hobby building though is being repurposed as a what was it, a work
and affordable housing for city, state, and county employees and teachers.
Oh, wow.
Yeah.
So we will all be able to get an apartment there someday, I guess.
Hopefully the rats will not be included when that time comes. So also talking about things that happened during the legislative session. As you're all aware, House Bill 1998, it did pass. It was signed by the governor. And so that has a lot of new changes that are coming up starting September 1st. The big ones are the National Practitioner Data Bank Continuous Query for our physicians and PAs, and the requiring of profile updates within 10 days. So hence where we got the staff to do that and administer it. But it also allows us to charge a fee for the enrollment of the licensees in that program and for the administration of the program. So we've done a lot of analysis to figure out how much that is going to be. And it's going to end up being $11 per application or per renewal. So every 2 years, they would pay $11. $5 is for 2-year enrollment in continuous query, and $6 is for administration of the program. That's the staff that are coming and doing the updates for the profiles. Another big change that came in 1998 was came through an amendment that was added to it for the funding of Texas PHP. And so as you probably remember, that's the one where it gets rid of the $1,200 annual fee for participants of the program. And now every licensee will be charged a small fee every 2 years to help pay for the program and increase funding that's available for it. So again, after analysis with it, it comes out that's going to be $5.25 per application or renewal. So between the two, between NPDB and Texas PHP, it's $16.25 for the funding of both of those programs.
Just I would very quickly mention here that one of the biggest concerns that was raised over the last couple of years is the timely reporting of our licensees of issues that came on the National Practitioner Data Bank or any other issues, felony convictions, whatever that might be. That was something of great interest out in the public. You know, as all of you know, it is the responsibility of the licensee to report this. Didn't necessarily happen in a timely manner, or in some instances didn't happen at all. Sometimes we would only get this information if a news report came out of a physician who was arrested for whatever, or just any licensee who was arrested for any whatever reason, and that would be the first time that we would know about it. This continuous query of the National Practitioner Data Bank essentially eliminates that as a concern, as we will be able to update the profile in real time as things get reported to the National Practitioner Data Bank, or as any other issues come up. The fingerprinting is the other part of that. It was essentially kind of grandfathered in that it would only be the new licensees or the new applicants would be required to fingerprint. Now moving forward, all licensees, as they renew their license, will be required to fingerprint, and that'll allow us, of course, to be able to get information on any arrests or convictions or anything along those sorts. So again, we hear what the public tells us and what their concerns are. And as they are brought to us, we bring up those concerns to our legislators. So, obviously at the end of the day, it's up to them on what they want to put forward as legislation. And these were things that they deemed important enough to put forward, and we're grateful to them for that. And these are some of the things that were passed in 1998 that we'll have moving forward.
Yes, absolutely. So as Dr. Zaffron said, we'll end up having all of our licensees fingerprinted. Again, they already have to do that for new applicants, but there was a large portion of our licensees that had been licensed before the fingerprinting requirement was in effect. And so this will make it where they have to do the fingerprinting upon their next renewal. Other changes that came out of it is with our experts, we can now use, if we can't find a licensee here in Texas to serve as an expert, we can get someone that is licensed through the IMLC. So we can get someone in another state that would be qualified to be licensed here in Texas. Some other changes when it comes to licensing is
interstate medical.
Yeah, the interstate medical licensure compact. Also changes for licensing is if someone has been revoked in another state previously for a revocable offense here in Texas, then they would be ineligible to get a license here in Texas. If they get revoked while they have a license, then they would be revoked here in Texas. So those are changes that are automatic now. And also there are more offenses that we can immediately suspend or restrict upon arrest. So that's any offense for criminal homicide, for trafficking in persons, sexual or assaultive offenses, if it's sexual, lewd, or indecency committed against a patient, a child, or an elderly individual. And then also it makes it a Class A misdemeanor for knowingly putting a false statement in an application for licensure, or a state jail felony if the intent is to defraud or harm the public. So 1998 is pretty encompassing. It adds a lot of additional tools for the medical board to help ensure that we're keeping the public safe. Some other changes are House Bill 1106, which is AccuDetox. So that is one of the things that we are still working through. What that did is it added licensed marriage and family therapists, licensed marriage and family therapist associates, PAs, to those who can perform AccuDetox by getting that certificate through the board. It also allows other licensed or certified professionals approved by TMB to do that. So that is something we're still working through of who else we think might fit that, have the training and education and requirement to do that type of procedure that is related to addiction, trauma, physical, emotional, or psychological stress. Other changes, SB 422 is licensure for military service members. So already the spouses of service members had some special licensing avenues, and that now extends it to the service members themselves. There'll be itemized billing requirements and TMB enforcement. So there's a lot of changes that have come up. And so we're working through any rules that we might need to implement due to these changes. As far as the rule update itself, staff is still going through the comprehensive rule update for all of our rules. They put a lot of work into this, but it'll still continue on through at least the rest of the calendar year. And a couple other things I wanted to touch on. There is litigation that is ongoing in the state around some bills that have passed here recently. And so just a reminder to the board members, if anyone does reach out to you, asking you to weigh in on any of these issues one way or another, or if the media is contacting you to make a comment about any litigation here in the state, please do pass those along to us and do not respond directly to any organizations or media members that might be trying to get a comment from you.
Yeah, and I will just chime in for a second. Not only do I think these need to be forwarded to legal counsel, but the other general statement I will make is that I don't think it's appropriate for any entity to ask us as board members appointed by the governor, confirmed by the Senate, to not follow the law. I know that there have been emails like that floating around. I understand that there are some passionate folks out there who feel very strongly about it. But regardless of what our feelings are, it is our duty as board members, as is for the staff, to follow the law. That's what we are here to do. So those requests, again, even though they may be passionate and heartfelt, but completely inappropriate as far as requesting us to not follow what the law asks us to do.
All right, thank you, Dr. Zafran. And that was all that I had for the executive director report.
Great, thank you, Brent. And a lot of work, as we said, were done not only by you, but by Tori and by others in the staff, Dr. Brett, Scott, and others who went and spent a lot of time testifying in front of the legislature, not testifying, but giving reports, answering questions, and sharing our perspective as things came up. Again, the stakeholders out there who are affected by what we do as regulators, thank you for being out there and also sharing your perspective. All that is extremely important as we come to a consensus in many of these items as we regulate the practice of medicine. The only thing I will add is, again, yes, we did add FTEs and we increased our budget, but also remember that our number of licensees in general has increased significantly, not only of licensed physicians with the Interstate Medical License Compact, but also with all our licensees in general. I think it's coming closer and closer to the 200,000 mark when you look at all licensees together. So it was absolutely necessary that we have enough staff and enough funding to be able to cover the services that we need to provide to all our licensees. All right, with that, I am going to go to Dr. Brett for the medical director report.
Yes, good morning, everybody. Just to give you some updates on the expert panelist situation. In addition to the statutory change that allowed us to use interstate licensure compact experts in circumstances, we've also had some changes with the expert panelist. Our panelist coordinator had left the agency, and so we've finally been able to fill that position. We actually have 2 individuals who are going to be helping with expert panelists, both assignments and onboarding of new expert panelists. So I don't have any solicitations for you for expert panelists at this time. We'll do it again in October. But certainly if you have anybody who's approached you and is interested, please do forward them on. We will follow up with them. Also presented to DPRC, they gave us direction to make some changes in our expert panelist process that should help reduce cost, help us recruit additional panelists, and decrease some of the turnaround times. So for those cases in which the first expert panelist does not find any standard of care violations, as long as that case did not involve a patient death or serious harm, we will be passing those on to DPRC for review, as long as there are no other identified issues. If that expert panelist, who will be appropriately selected based on their specialty or subspecialty certification, does find a violation, then we'll follow our normal current procedure of sending that on to an expert, a second expert. So anything you see at ISC won't change. Those will still get to experts who come up with a consensus report. This should help. We're also looking at increasing the reimbursement for the expert panelists. Up until now, in the 10 years I've worked for the board, we have not changed that remuneration amount, and basically our experts were doing this essentially as volunteers. We made that, we're going to be making that a little bit more competitive, still nowhere near what they could get at doing these reviews for other organizations, but doing the best we can. And that should help us recruit and retain experts. So that concludes my report to y'all. October should be a little bit more normal with respect to recruiting additional experts and specialties. And hopefully I'll be able to give you a report then, if not then in December, as to some of the results of the changes of our underlying expert practice that we should put into place on September 1st.
Thank you, Dr. Brett. Ms. Sloan, public information update.
Tori is not here today, and I think Jarrett might be out too. But that's why I wanted to go ahead and kind of give more of a rundown on the legislative update and some of those bills that had passed.
Okay, great. Thank you. Ms. Gottschalk, is Ms. Gottschalk on?
Yes, I am.
Hi,
I don't
is
have
there
any.
a physician assistant liaison? Thank you. Is there any update from you guys?
No, there is not. Thank you.
Great. Thank you, Melinda. All right. Number 19, consideration and possible action regarding pending litigation. Mr. Frischauer.
Yes. Good morning, everyone. As usual, the report kind of sounds like a broken record. I do want to reiterate what Dr. Zafran and Brent had said. We do have some fairly controversial lawsuits going on right now, including ones related to some of the transgender care bills and some related to the abortion law. The board gets named in those because we have the enforcement authority. And when you, no, just, we don't want any comments on that. What I'm telling you is, if you get the inquiries, as Dr. Zafran said and Brent said, because it's ongoing litigation, we just simply need to know. We, as I said, we're named on all of these, but really the Attorney General does almost all of the work on those. You know, they may get some background information on us. Do we have complaints? That kind of thing. But otherwise, if you get those or you're uncertain, just forward them on, as Dr. Zafran and Brent have indicated. My staff will look at them quite often. Jarrett and Tori in our public information officer and in the government affairs and communications office, they get them as well. So we will handle those for you. Now, as far as regular litigation, we do have a couple of standard appeals that are going through the system. We've been getting affirmed in the court, so we're doing very good, meaning your final orders are very much appropriate in regards to the sanctions based on the findings. We do have a couple of cases where the appeals, they're trying to get appeals up to the Supreme Court, where we have been upheld in the Third Court of Appeals. Those we just sit and wait, and if the Supreme Court decides to take them, this is Texas Supreme Court, we will be notified, but those are all discretionary reviews with that court. We are involved, and again, named in some of the opioid litigation lawsuits that are going on across the country. We are not named as a party, or you as a board are not named, but we are getting requests to produce documents on our investigations for the ongoing litigation between some of the pharmaceutical companies and some, states, cities, counties. But again, we've got the Attorney General representing us on those, and we have quite a few objections because they basically, in many cases, are looking for lack of a better term, everything under the sun we ever did related to opioids. So we're saying that's too much of a burden on the agency, and there's some case law that gives us some protections. Otherwise, there's just a few suits going on here and there that we've got the AG on, but nothing of a great deal of significance that's gone through the system other than the routine items. So with that, I'll be glad to answer any questions. Otherwise, Dr. Zafran, that concludes my report.
Great. Thank you, Scott. Any questions, board members? All right. The next series of items are reports. I'll just go through the reports that we actually have. If you have any items that you want to discuss, just stop me. Let me know. There's a report on temporary suspension hearings, report on suspensions by operation of law, report on motions for rehearing requests, report on cease and desist orders approved by the executive director. There's a report on automatic orders. Beyond that, there is nothing as far as rules that are being proposed. As Brent has indicated, there's a review process that is going on with all those, and you as board members will have an opportunity to receive those proposed cleanup of some of the rules out there before we consider them at the next board meeting, if it is going to be ready by the next board meeting. So you'll have that with enough time to review and be able to look at before the next board meeting. With that brings us to agenda item number 35, which is an open forum for public comment. And I'll hand it back off to Brent.
Yep, thank you, Dr. Zafran. Like you said, there's nothing for items 25 through 34, so we're able to skip right down to the public comment section. This is the time where anyone that has joined us from the public, if they would like to say something to the board, is your opportunity to do so. Your comments will be limited to 3 minutes. Please keep in mind that anything you say to the board may be limited in what they can say in response. So if you would like to say something, please go ahead and raise your hand. If you're here in Teams, there's nobody here physically with us in the room. But if you have just joined us by phone, you can also be sure to unmute yourself and just go ahead and state your name. Not seeing any hands, icons coming up. Oh, there's one. Let's see.
Am I allowed to just unmute myself and talk? Sorry, I don't know how this works.
Yeah, just 1 second. We'll get you going here. So it's just the one. Okay, there are two. You see what the. Yeah, who else we got? All right, while we get the other one queued up here, showing your name is Julia, is that correct?
Yes, that's correct.
Okay, if you go ahead and just state your full name and the clock will start.
My name is Julia Heilrein. My pronouns are she, her. I'm a born and raised Texan, and I'm currently a nursing student here. So I know that y'all aren't directly the board who controls my life, but adjacent. As y'all know and mentioned briefly, there are 14 days until Senate Bill 14, which bans gender affirming care for transgender minors in the state of Texas, goes into effect. As you are also all aware, gender affirming care for trans and non-binary individuals is scientifically proven to be safe, effective, and ethical. And this care, including psychotherapy, hormone replacement therapy, and surgery, is endorsed by the American Medical Association, the American Academy of Pediatrics, and nearly every other major reputable medical organization. I know that you said that you didn't want anybody on here asking you to break state law. That's not what I'm doing. I understand that if the bill goes into effect on September 1st, it is the way that it is. But I am here asking you today what your plan is should SB 14 go into effect in 2 weeks as it's scheduled to do so, or with this ongoing litigation if it goes into effect later, to protect both providers and their patients, because when you're talking about these trans and non-binary kids in the state, they're some of the most vulnerable patients that we have.
Okay, thank you, Julia, for your comments. Again, as you heard us say earlier, with issues like this, the board's not really at a place where it can make any public comments about it. So unfortunately, we're not going to be able to answer your question directly. We do appreciate you being here and letting the board know your feelings on the matter.
Thank you.
Thank you. Okay, I'm showing next. Is it Arwen?
That's correct. Yes, Harlan. Oh, my name is Harlan Carroll. Can you hear me?
Yes. Yeah, I think we're looking at someone else that has a similar sounding name, Arwen and Harlan.
Oh, my bad.
No, that's okay. So I think Arwen was first before you, Harlan. So if Arwen, if you'd like to go ahead.
Yes. Hi, my name is Arwen Heilrein. Thank you so much for having me. I am 18 and I identify as genderqueer. I was 13 when I told my parents that I didn't think that I was a girl. They have always made sure that I have access to the medical care that I need to feel comfortable and confident with who I am. Through the years, I've grown into a person who I'm proud to be. There was a time when this was unimaginable to me. I didn't see any possible future where I was really happy. I know that many of my trans friends have felt the same way. The first time that I had a doctor ask what pronouns I preferred and really listen when I answered, I had a wonderful feeling because a medical professional saw me for who I really was. I don't like thinking about who I would have grown up to be if I didn't have support from medical professionals, if that person would have been happy or proud of who they are. The American Medical Association has supported gender affirming care for youth. I understand that you must obey state law. I support obeying state law. However, I am asking you to take into consideration the fact that the people who make statements for the country based on what is appropriate, safe, and good ideas to do in terms of medical care have said that this is appropriate, safe, and a correct thing to do in terms of medical care for children. I'm asking you to keep that in mind if this law goes into effect, and to please keep in mind the kids that this is going to be affecting. Thank you.
All right, thank you. Appreciate your comments. Harlan?
All right, my name is Harlan Carroll. I'm a transgender man and a lifelong Texan living near Austin. I'm providing public comment here today to demand that the Texas Medical Board live up to its duty to promote the health of Texas residents and stand up for doctors who want to provide scientifically proven care for trans youth. The board should publicly announce that he will not delicense doctors who provide transition care for minors. As a trans Texan, this topic is obviously very personal and important to me. I'm only in my early 20s, and only a handful of years ago, I was in the exact same position as some of these kids. And I can tell you from firsthand experience, even having access to the knowledge that gender affirming care was an option would have been life-saving for me. If I had been able to come out and access the transition care I needed in an affirming home environment and an affirming school environment, I can tell you for certain that it would have saved me multiple suicide attempts and years of deep, hopeless depression. I urge you to do the right thing and not strip the hope of a full life away from trans Texas youth. The LGBTQ community of Texas demands you refuse to comply with SB 14 and not delicense medical professionals who provide life-saving, gender-affirming care to trans youth. As you're likely aware, in July 2023, a lawsuit was filed on behalf of 5 Texas families, 3 medical professionals, and 2 organizations representing hundreds of families and health professionals across the state. The entities being sued are the state of Texas and its Attorney General, Health and Human Services Commission, and the Texas Medical Board. The ACLU is filed on grounds that SB 14 is unconstitutional. Not only is it unconstitutional, but it's blatantly discriminatory and goes against the best proven medical practice treatment for an already vulnerable population. ACLU has sued and won in multiple other states that have passed similar bans, blocking these laws from taking effect. In the Florida case, a federal judge ruled last month that the bill would have caused trans youth to suffer irreparable harm. I feel it's important to note that a good deal of the research supporting SB 14 was publicized by a group that is outright biased and classified as a hate group by the Southern Poverty Law Center, the American College of Pediatricians. This group also claims that having gay parents puts children's health at risk, likens homosexuality to pedophilia, and endorses conversion therapy. This group aims to sound official while being a fringe extremist group peddling hate speech and junk science. And on the other hand, the American Medical Association, the American Psychological Association, and the American Academy of Pediatrics all oppose bans like SB 14. The Trevor Project found that 3/4 of trans youth who felt they needed gender-affirming care but couldn't access it experienced depression as a result, and a staggering 27.7% of 13 to 17-year-olds unable to access gender-affirming care attempted suicide. That's over a quarter. In federal surveys administered between 2017 and 2019, it was estimated that 29,800 Texans between the ages of 13 to 17 are transgender. If SB 14 is enforced, it will be
30 seconds left.
For the trans youth of Texas who already face increased rates of depression and suicide, you have the power to do something to the safety and health of Texas' next generation. Undeniable statistics show us that denying trans youth this care will lead to needless suffering and potential deaths of children in this state. You take an oath to refrain from harm or hurt, do the right thing, and officially refuse to comply with the discriminatory, unconstitutional SB 14. Thank you for your time.
Thank you, Harlan. We have another hand up. Is it Samuel? Samuel, are you there?
Yes, can you hear me?
Yes, we can now.
Okay, excellent. Yeah, my name is Sam P. Reeves, and I'm a resident of Austin, Texas. I am here to urge you to publicly announce your refusal to comply with SB 14's provisions, requiring you to strip healthcare professionals of their licenses for providing gender-affirming care to minors. As you almost certainly know, there is a very large body of medical science spanning decades proving the benefits of these soon-to-be banned treatments. This is laid out thoroughly among other places in Lowe versus Texas, the petition recently filed in an effort to halt and overturn this law. In addition to profoundly improving quality of life, these treatments often enough mean the difference between life and death. We want to emphasize that it is children in particular who are being directly targeted by this cruelty. That is who we are calling on you to stand up for. It would not be surprising if you were quietly opposed to the mandate SB 14 would impose on you. If you have even slight respect for medical science and any sense of your duty to proactively foster the health of Texas residents, then you do not want to harshly punish any physicians with the courage to provide care to these individuals whom the legislature would like to see annihilated. You may be hoping that the law is tangled up in the courts, so you were not put in a position of having to take a stand, and in doing so, take a risk. It's one thing to cross your fingers and hope no doctor is brave enough to put you to the test to see if you will actually enforce your end of SB 14, but waiting and watching doesn't take any courage. It is lukewarm. What would be courageous, humane, and decent would be to announce that as long as you hold your position, you will not punish doctors who wish to do the right thing and continue to provide this life-affirming, life-saving care to trans youths. That kind of support from you, especially combined with ordinances like those that organizations I'm involved in are urging the Austin City Council to pass, would create the opening that those doctors need to keep providing this care, and let the bigots in the legislature be damned. Thank you for your time.
Thank you. Julie?
Hello. Can everyone hear me?
Yes, we can.
All right. I am Julie Lacey. I live in Texas. I've lived in Texas my entire life, and I am adding my voices to the others who have called to ask on you to keep in mind the needs of trans youth in the event of SB 14. The Trevor Project, which is a nonprofit that focuses on young LGBTQ plus individuals and suicide prevention, has found that 27.7% of 13 to 17-year-olds who wanted gender affirming care but could not access it attempted suicide. I understand state law and is state law, but I do ask that the board keeps in mind how vulnerable this group of people is and how vital this healthcare is that is being targeted with SB 14. Thank you for your time.
Thank you, Julie. Anybody else have any comments they would like to make before the board today? Okay, not seeing any hands up. I'll give another few seconds to see if someone happened to have joined us by phone. Again, be sure to unmute yourself and state your name. Okay, not hearing any. I think that completes everyone that seems like, oh, there's a hand that did come up. Looks like Alex. Alex, you can go ahead. Oh, well, the hand went down. Okay, Alex, your hand's back up. You can go ahead and state your name and make your comments. We're not hearing you if you are talking. Alex may be having some difficulty. All right, we'll give it a few more seconds, see if Alex is able to get back in and start making the comments. But we do want to thank everyone that has stuck around to this point to make comments to the board. Again, it is an important part of the board's function and responsibility of hearing from the public on things that the board may need to take into consideration for any future action, a board meeting, or policy considerations. Okay, not seeing Alex come back up here. Alex, if you do have something that you would like to share with the board, you can get in touch with us and get your comments submitted to us in writing if you would prefer. But I think that does complete our public comment section for agenda item number 35.
Great. Thank you, Mr. Carlton. The next agenda item, number 36, is discussion, recommendation, and possible action relating to personnel matters.
I don't believe we have any for today.
All right, so we will move on to the consent agenda, and my understanding is that we have everything submitted in, so we should be able to go ahead and proceed with that. So number one, which is just number one, actually, no, there is a number two. So consideration and approval of the June 9th, 2023 Medical Board meeting minutes and action items, and committee reports and the consideration and approval of minutes and action items of committees meeting during the board meeting. Is there a motion regarding the consent agenda agenda items number 1 and number 2?
Move for approval.
Deloach,
Okay, I think I saw Dr. Quinones and Dr. Deloach.
Yeah.
Okay.
All right. So there's a motion and a second. Is there any further discussion? All right, seeing none, all those in favor of consent agenda items number 1 and 2, please say aye.
Aye.
All those opposed? All right, motion passes. With that, I will entertain a motion to adjourn.
I'd like to make a motion to adjourn.
All right, motion to adjourn by Dr. Farmer and seconded by Ms. Barnes. Is there any discussion? All those in favor, please say aye.
Aye.
All those opposed, say nay. The motion passes. The board meeting is now ended at 10:44 a.m., August 18th, 2023. Thank you, everyone, for participating, and please have a safe day and a safe weekend. Thank you.
Thank you.
Thank you, everyone.
Thank you.
Bye.